Hello friends, very warm welcome to my Business Loss channel. So today friends, in this video I'm going to discuss the last year's question paper for OBE examination. For BCom Honors, this was a paper which was asked in the BCom Honors course first semester in the last year in the examination which were held in the month of March 21. So friends, the question paper is before you. There are 6 questions. I told you in one of my video classes that in OBE there are 6 questions which are asked and regarding this weightage of each unit for the OBE examination. I have told you 2 questions are from ICA. Third question is from the Sale of Goods Act. Third question is from Special Contracts. Fourth question is from Sale of Goods Act. Fifth question is from LLP. And the last question is from IT Act. And out of 6 friends, you have to attempt any 4 questions. So today in this video lecture class, I'm going to discuss this paper. The paper is before you. The very first question is, an agreement without consideration is void. Comment. Also solve the following case law. Giving reason for your answer. So friends, first of all, I would like to discuss the very first question, theory question, and then I'll come to the case law. An agreement without consideration is void. You all know, friends, that an agreement which is made in the absence of consideration is not valid, it is void. This is the law, this is a rule, general rule. An agreement which is made in the absence of consideration is void, it is not at all enforceable in the court of law. But there are some exceptional cases where this rule is not applicable. Meaning thereby, an agreement which is made in the absence of consideration is not void, it is valid. 9 exceptional cases are there, friends. Agreements made on account of natural love and affection, compensation for past voluntary services, agreement to pay time-barred debt, then completed gift, contribution to charity, remission by the promisee of the performance of the promise, contribution to charity, contract of agency, then contract of guarantee, and contract of bailment, gratuitous bailment. 9 points you will have to write, friends, along with the requirements which are given under section 25, 1, 2, and 3. And then you will have to add case laws and examples. 3-4 case laws are very important, friends. Venktasamy versus Rangasamy, Rajlakhi Dabi versus Putnath Mukherjee, and then Abdul Aziz versus Mazoom Ali, and Kedarnath versus Gauri Muhammad. So all these, friends, you write along with the case laws or examples. All these 9 points, because this question will be of 12 marks. And the case law, which is before you, this will be of 6 marks. Theory question 12, 3/4 marks, and this question 6 marks, because paper is of 75 marks. And you are asked to attempt any 4 questions. So each question will be of 18 3/4 marks. Now coming to the case law, friends, I would like to read it first and then tell you how to answer this case law. Ashish owes a sum of rupees 20,000 to Dinesh. The debt became time barred by the Law of Limitation Act. Does Dinesh have any legal recourse against Ashish? Ashish's friend gives in writing to Dinesh to pay rupees 20,000 after 3 months. Now what legal recourse Dinesh has? So friends, the agreement took place between Ashish and Dinesh. Ashish was a borrower, Dinesh was a creditor. So he borrowed 20,000 rupees from Dinesh. The debt became time-barring debt. Friends, under the Law of Limitation Act, the debt becomes time-barring debt after the expiry of 3 years. It is given in the question that debt has become time-barring debt. Does Dinesh have any remedy against Ashish? No. Because debt has become time-barring debt. When debt becomes time-barring debt, debt does exist. But the right of creditor to sue the debtor is lost. The debt is irrecoverable because the right is lost now. Okay, so Ashish friend gives in writing to Dinesh to pay 20,000 after 3 months. Now here friends, one of the requirements is that if the debt has become time barring debt, but the promisor has given the promise in writing that to pay part of the amount or whole of the amount, then even if there is no consideration moving from the other party's side, still this agreement will be enforceable. But the point is, friends, Ashish friend has given the promise in writing. Promisor has not given the promise. Another person who is a friend of promisor has given the promise. Now, Dinesh will have no right, to sue Ashish friend if Ashish friend does not make the payment. Because one of the requirements is that whosoever is the promisor, he should have given the promise to pay part of the amount or entire amount. But if promise is given by somebody else, then that promise cannot be enforced in the court of law. So friends, like this you will have to answer. Read every word of the case law carefully. Each and every word will have its impact on the answer. So friends, whatever I have explained, you must have understood. If you still have any doubt, you can always write in the comment section. Coming to the second question, friends, certain relations resembling those created by contracts. What are they known as under the Indian Contract Act? And discuss them, giving examples of each of them. So friends, these are the quasi-contracts or constructive contracts. You all know, friends, quasi-contractual obligations which have been provided under section 68 to 72 of ICA 1872. So friends, as such quasi-contract or constructive contract, do not find any place under the Indian Contract Act. They have not been defined as such. There's no offer, there's no acceptance. Still, these obligations created by the law are known as quasi-contracts, and they have the same consequences as the contract has. Supply of necessaries to incompetent person or any person who is dependent upon the incompetent person. Then payment made by interested person. Non-gratuitous act. Responsibility of finder of goods. When money is paid by mistake or goods are delivered under coercion. All 5 points along with the requirements, case law or section 68 to 72, you will have to write, because this question is of 18 3/4 marks. Just writing 1-page answer, 2-page answers, you will not be given good marks. So answer should be proper. This is a long question of 18 3/4 marks. Note carefully. So the answer should be a proper answer. All 5 points should be written along with the theory content as well as examples or case laws. Coming to the third question, friends, which is A pledges with B jewels worth ₹1 lakh and borrows ₹50,000 at 10% interest per annum, promising to repay the amount and redeem the jewels within a year. A default in returning the money borrowed. What legal remedy B has against A decide? Now for these case laws, friends, writing yes or no is not enough, because case law is of 5 to 6 marks in the question. Though, in this breakup is not given, but generally the problem is of 5 to 6 marks. And second part of the question is, and also discuss the rights and duties of the pani and the paner under the Act. Now this case law pertains to the pledge. A is a pledger and B is a pledgee. A has pledged his jewelry with B worth ₹1 lakh, and on the basis of that he has borrowed the amount of 50,000 rupees. Okay, so and he has to repay the debt within a year. But he has defaulted. He has not paid the money. Now the question is, what remedy B has against A person? So friends, whenever pledger takes any amount of loan from the pledgee on the basis of security, then it becomes his duty. He must repay after the specified period. If he commits default, then in that case, pledgee has a right. He can give notice to the pledger. He can give ultimatum to the pledger. You have to make me the payment. If you do not make the payment, then I will sell this movable asset. If despite getting the notice, pledger doesn't make the payment, doesn't pay any heed to this, then pledgee will have the right. He can dispose of that movable property in the market and can realize his amount of debt. So this is a remedy, friends, which is available to the pani, to the pledgee. What are the rights and duties of the pani and the pledger? Pani means the pledgee and paner means the pledger. So friends, rights of pani are the duties of paner, and duties of pani are the rights of paner. And rights of pani are the duties of paner, and duties of the pani are the rights of paner. So friends, duties of one are the rights of another. Like duties of pani is that he has a pledgee has no right to use that item. Okay, so pledgee cannot file a suit against a pledger before the expiry of the specified period. This is his duty, but which is the right of the pana. Within that period, he has a right. He can redeem his debt. So friends, you all know if the pledger commits default, then the right is available to the pledgee and that he can dispose of that asset in the market and realize his amount of debt. And if it is short of, then he can file a suit for the balance amount against the pledger. So all these, friends, you will have to write under the heading rights and duties of the pani and the pana. Moving ahead, the next question is, state the rules in regard to delivery of goods from a seller to a buyer in a contract for the sale of goods, and also solve the following case giving reason for your answer. So this is question number 4, which is from the Sale of Goods Act. Again, 18 3/4 marks. Friends, first question, the part I mean to say, this pertains to delivery of goods. The term delivery of goods has been defined under Section 2, subsection 2 of the Sale of Goods Act 1930. It is the voluntary transfer of goods by one person to another. If goods are possessed forcibly at the gunpoint or knife point, that will not amount to delivery of goods. And then, there are 12 rules which have been provided under sections 31 to 40 of the Sale of Goods Act 1930. All those 12 points you will have to write along with the theory content as well as examples or case laws. Because question is of 12 3/4 marks. Okay, then only you will be getting good marks. If you have written the content correctly, then out of 12 3/4, 11 marks, or maybe if it is exceptionally too good, then evaluator can also give you 12 marks. Coming to the case law, which is A gives some diamond to B on sale or return basis. On the same day, B gives those diamonds to C on sale or return basis. From him, the diamonds were lost. From him means when the diamonds were in the possession of C, they were lost. Who will bear the loss? So friends, when the goods are sold on sale or return basis, then there are certain rules which are provided under section 24, they shall apply. Here in this case law, A has sold diamond, A has given the diamond on sale or return basis to B. If it is approved by B, it will amount to sale, and if it is not approved by B will return this to A, or B will inform this to A that I have not approved it. Now B has given that diamond to C on sale or return basis on the same day. So this act of B amounts to implied acceptance. The moment he has done this, it means ownership has passed from A to B. And now in the possession of C, diamond gets lost. then friends, the loss has to be borne by he. Because risk always follows ownership as per section 26. Whosoever is the owner at the time of destruction of goods has to bear the loss of destruction of goods. So here the loss has to be borne by B because he is the owner of diamond. Implied acceptance on his part when he has given that diamond to C on sale or return basis. So our answer is B shall bear the loss. And now coming to the next question, which is question number 5. This is from LLP Act 2008. Question number 5. Second last question. A limited liability partnership is in law a different person altogether from its partners. Comment on the statement and discuss the provisions regarding the incorporation of limited liability partnership under the Limited Liability Partnership Act 2008. So friends, here, this is very true that LLP is a separate legal entity. It is not the totality of partners. It is a separate legal entity which is different from its partners. Okay, LLP has to be registered. Registration of LLP is must under the law. LLP is a separate legal entity. LLP can own assets, movable assets, immovable assets, tangible assets, intangible assets, and LLP's assets are the assets of LLP only. LLP's creditors are the creditors of LLP only. LLP is a body corporate. It's a separate legal entity. Being a separate legal entity, can sue others and can be sued by others. So you will have to write features here, and then after that, you will have to write comment on the statement and discuss the provisions regarding the incorporation of LLP. There are 6 steps involved in the incorporation of LLP. There are some guidelines regarding name of LLP. Now new guidelines have been incorporated under this LLP Amendment Act 2021. We'll have to write those new guidelines. And then, so all these steps, 6 steps in the formation of LLP. 6 steps you have to write, friends, regarding this: who can be a partner, then digital signature certificate, designated partners. So and then documents are to be filed online with the ROC. If ROC is satisfied with the documents and he finds that documents are in order, then the certificate of incorporation will be issued by ROC to the LLP. 6 steps along with the explanation sections you will have to write in the answer for this question. Now coming to the last question, which is how is Controller of Certifying Authorities appointed? Discuss the functions and powers of the Controller of Certifying Authority under the Information Technology Act 2000. Controller of Certifying Authority is the CCA. CCA is always appointed by the central government. Central government, if the central government desires, central government can also appoint deputy controllers or assistant controllers through the same notification or through the subsequent notification. So CCA is always appointed by the government, central government. CCA is always answerable to the central government. And then we have CA. CA is a person who issues the digital signature certificate or electronic signature certificate to the subscriber. CA is always answerable to the CCA, and CCA is answerable to the central government. So there are functions which are to be performed by the CCA, 4 functions with subpoints, and these functions have been provided under sections 18 to 25. So CCA is apex body, has lot of control over the CA. So all functions pertaining to CA means if there is any conflict between the CA and the subscriber, that will be resolved by CA. What will be the format of digital signature certificate? How the digital signature certificate will be issued? Okay. What will be the format of private key, public key? All these have to be decided by the CCA. And then there are 8 points regarding powers of CCA. All 8 points you will have to write in the answer for this question, because entire question is of 18 3/4 marks. All 8 points under the power and 4 points under the heading functions of CCA. You will have to write along with the explanation. So this is all from my side regarding discussion of this last year's OBE paper in Delhi University. It is all from my side, friends. I hope you must have understood the discussion of this paper. And if you have any problem, any question you have, you can always write in the comment section. So I hope you must have got great learning from discussion of this paper. Do subscribe to my channel if you have not subscribed yet. Goodbye, friends. Take care of yourself. Stay blessed always and keep smiling. Okay, goodbye.